Hi, Bill Henshaw here again for the Constitutional Crisis Channel. Another one of our Christmas era videos here. You're going to like it. It's a little offbeat, not current events or anything like that, but just indications of what they don't teach you in school anymore and how costly that can be. Knowledge is power. Don't ever forget that. Now, that said, this video might seem to some people who are on the same wavelength that I am, like I'm doing a Robert Langdon type discussion, on symbology and things like that out of the Da Vinci Code, one of my favorite movies, by the way. And that's a great. And Dan Brown, by the way, anybody that you know that reads Dan Brown, that's a person you want to pay attention to. That's a serious person. Da Vinci Code, Angels and Demons, Deception Point, Digital Fortress, all great books to read. That said, when I first started out, I very soon had intervention of a very learned individual up in Oregon named Robert Wangrud, and he put out a newsletter that was really a marvel once a month, and I have almost all of these now, and the work they did then without computers. You wonder how in the world they got a hold of some of this stuff, but they did. But the point here is that he must been genealogically challenged or something, because his father also was one of these people that didn't have any use for the Internal Revenue Service and the de facto National Socialist government. And he wasn't in love with being a taxpayer and filing taxes either, and he proceeded not to do so for a while. Well, they caught up to him, and this is a while back now, and they brought charges against him for willfully failing to file a tax return. And Robert Wangrud's dad was also named Robert, sat through, I think, every day of the trial, he told me. And when it got time for cross-examination, the U.S. attorney comes up there and walks up to the stand and hands his dad the Internal Revenue Code and opens it up to a certain page and says, "Mr. Wangrud, look at this book. Do you see the dollar sign here?" He looked at it and said, yes, he did. And he got convicted because of it, because that meant that he knew that he had quote-unquote income, that he should have filed a tax return, and he should have paid the damn taxes. That rankled Wangrud for years after, until his untimely passing away in 2000. I can't believe it's been that long. But had he known the right answer, and we didn't get it at that time, even though Mr. Wangrud Sr. was taught this, no doubt, when he was in school, the real dollar sign looks like this. My cameraman's going to hold it up. Take a good close look at this one. And you'll see that that's an S with two bars through it. Now, that started out, and the reason it's that way is that if you connect the bars underneath, what you get is a U over S, United States. That symbolizes gold and silver coin, also known as specie, S-P-E-C-I-A, not necessarily known as quote-unquote lawful money of the United States, especially the way the 9 old parts are defining on the Supreme Court. But it should be defined that way. What Mr. Wangrud saw in the Internal Revenue Code is this. This is a one-bar dollar sign, and that's all they have in there. And what that means has nothing to do with gold and silver, has nothing to do with states, but it means what the Federal Reserve admits are evidences of debt. Federal Reserve notes. That's all there is. Now, if he had made the right answer there, he probably doesn't get convicted, because then it's going to make relevant all of the arguments he wants to bring in on a constitutional basis. Now, true enough, we didn't know 40 years ago what we know now. But he might actually have won the case with the simple, correct answer to one question. Because that would have thrown the U.S. Attorney off so much that he even knew the right answer to that question. The U.S. Attorney himself might not have known it. That said, when I was growing up, and I'm old enough now that, when I was growing up, we actually just still had at least silver coin in circulation up until 1964. We were taught this as far back as second grade with Miss Moss, that when you made a dollar sign with that, you had the two-bar dollar sign. That's the one that we used, and that's the one that was accurate at the time. Other people, my cameraman included, who came in the education system somewhat later, up until the late 70s, tells me that was the case even then, even though, with the ceasing of silver coinage in 1964, there was no need to use that double-bar dollar sign since they didn't exist anymore. But the government, had they done that right away, it might have given the game away, because there would have been a lot of people smart enough to realize what the hell is going on here. So they kind of phased it in kind of subtly, which is what these people tend to do over the years. sometimes as much as 30 or 40 years, so that people don't notice it. And they made that change, and now every time you see a dollar sign, you're going to see the 1-bar type, not the 2-bar type. Now, I'm very careful in my documents, and the ones you receive from me, in the places where it's appropriate, you will see a 2-bar dollar sign. And that means gold and silver coin, and that means that we are entitled as a matter of right to a jury in a state court of common law general jurisdiction. If you go the other way, they think not only are you not entitled to a trial by jury, and a big case on this is Blanton v. North Las Vegas, Blanton, 489 U.S. 538, 9-0. The court says, courtesy of Thurgood Marshall, it was so easy even he could write it, that there's no right to trial by jury in a criminal misdemeanor case. You have no right to that. What you have a right, maybe have a right to have, is an administrative hearing in what is, in effect, for all apparent intents and purposes, an admiralty and maritime setting. Because that's what interstate commerce is. The Supreme Court has said that too. Dead bang. That's what it is, admiralty and maritime. But wait a minute. Maybe they didn't teach you this when you were in school, but I did at least get little bits of information like this one, that admiralty was claimed by the framers of the Constitution and those that wrote the Declaration of Independence, Thomas Jefferson in particular. Admiralty was described as a jurisdiction foreign to our Constitution and unacknowledged by our laws. That was the whole basis for the damn revolution to start with. King George III was misusing admiralty jurisdiction to issue general warrants and other things like this, and that's what caused the whole thing. And now we're back to being subject to the same jurisdiction with the Internal Revenue Code? Can you tell me how that's possible? Or better yet, can you tell me how a jury of 12 of my peers are going to buy that as a legal argument from the de facto National Socialist government? I don't think so. Teeny little thing like the dollar sign. Looks like it's nothing to it, not important. Who cares? Well, you ought to know by now, you damn well should care, because this is the way out. And you get them to force them to admit what it is they're doing. And when they do that, they then have to admit they don't have any jurisdiction, and the case has to be dismissed, and you go along your merry way, and they leave you the hell alone, which is what all of us should want them to do. Now, continuing the subject matter about the dollar sign, the 1- and 2-bar dollar signs, how important is this? Well, if you go back and do your research and study, as I have done, and things they should be teaching you when you're in school in their mandatory public, quote-unquote, education system, well, you read a case like Cohens against State of Virginia. That's Cohens. They were Cohen brothers that were involved here, versus the State of Virginia, 19 U.S. 264. And during the course of this opinion, Chief Justice John Marshall, that infallible icon of Harvard and Yale, said right in there. He said about the uses of paper money by the State of Virginia, which is being challenged then, let it be that the discharge of the obligation does not extinguish the debt. It is still due. And that's what you should be thinking when you, for example, get a paycheck and all they've done is use Federal Reserve notes to discharge the obligation. The debt is still due. And even if that debt might be taxable income, and it won't because it's property, and they can't directly tax property like that. A big case on this one is Pollock, Pollock, versus Farmers Loan and Trust. I believe the citation on this one is 156 U.S. 1, but check the notes below. I may have gotten the citation wrong, but check this, 1895. Can't do it. This is how important this is. And you got Chief Justice John Marshall saying it, that states cannot use paper money to do transactions. And in 1819, that was true. I believe it still is. And note 1819, that's within 30 years of the Constitution. People living at that time knew what the hell was going on. You couldn't lie to them like what you can do these days. And that's why Marshall had to do what he did. So anything you get from him that supports our cause, that's an eminent source that you want to cite, because if he was wrong about that one, and it looks like he's never wrong, he even has a better pedigree for perfection than the Pope and the Vatican, for crying out loud, then he must have been wrong about some other things later on that we'll discuss in other videos. Now, furthermore on this subject of the dollar sign and lawful money, when you get right down to it, you think about the application of usury laws, and my cameraman and friend has made a good point here. How do they come into play? Well, they do, because, the Fed admits that these are evidences of debt and they're worthless. Therefore, any amount of interest on a loan of this type, quote unquote loan, would be a violation of the usury laws. It has to be. If, on the other hand, you're a lawful de jure free white state citizen and you're dealing in gold and silver, now you have even better underpinnings, a lot of which can be found in the Old Testament of the Bible, that talk about the fact that usury is prohibited. You can't do it on gold and silver coin. So either way, we're going to get it. But you can make this argument even if you've been defrauded into becoming a 14th Amendment citizen, because of just that fact, the fraud and the treason that the government used to induce you to do it. You did not make a voluntary, knowing, and intelligent waiver of rights. That's the Supreme Court's reference standard for it. Case is Johnson v. Zerbst, Z-E-R-B-S-T, 304 U.S. 458. You can look it up. That's what they use, and I'm going to hold them to it, and you should too. Thank you.